Hi, I'm Mike Winkler, and I'm the Principal Managing Broker for Coldwell Banker Bain in Issaquah, Washington.
And I'm E.J. Bolds. I'm the Principal Managing Broker for Coldwell Banker Bain on Mercer Island, Washington.
EJ, in our last video blog post, we talked about neighborhood review as part of our buyer protection series.
That's
and
right.
so it seems logical that we should get to the Form 17 seller disclosure.
The Form 17 seller disclosure is mandated in form and in content by the Washington State Legislature. The process really is by custom and by law that the seller would disclose defects that they know about in their property, and the Form 17 is the vehicle in which they would make those disclosures.
Some exemptions for the Form 17 include foreclosures, or properties that are taken back by the banks through the foreclosure process, estates, transfers to and from family members, so for example a divorce or within a trust. Builders are exempt under certain sections, in this case specifically 4 and 5, and public offering statements, which is where condos, for example, are conversions and they do it through a public offering statement process.
One of the things that is most misunderstood about Form 17 is people that own rental property, for example, will say, I've never lived in the home, so I must be exempt from the Form 17. That's not correct. Just because you've never lived there doesn't mean you wouldn't necessarily have to fill out the disclosure form itself.
One of the other things is that sellers say, well, what exactly, what if I don't know? And so when a seller fills it out, they really fill it out to the best of their knowledge, and don't know is an acceptable answer.
It is, and the process for the Form 17 is that the buyer receives a completed Form 17 from the seller. This can happen really at any time before, during, or after the contract has been written. It's usually during the pending process that the Form 17 is given to the buyer. The buyer then has 3 days to review the Form 17, and they can actually terminate or rescind the agreement unilaterally, so for any reason or no reason, I guess, and get their earnest money back. And they can do that based on the information they've seen in the Form 17.
And EJ, I think you'd agree, based on our experience, that the trump card that the buyer always holds is an inspection. And in fact, in some of the, now we're not lawyers, and we'd always recommend that you seek legal advice if you need to, but the outcome of several legal cases in Washington in particular are that when buyers feel like they've not gotten the whole disclosure from a seller, the courts have said that the buyers had an opportunity for a, quote, diligent investigation, which may exceed the standards of what is most commonly known as a home inspection. But the bottom line is, if you feel like you need to go the extra mile and do a greater inspection than what the inspectors are going to suggest, you have that right. You can negotiate it out with the seller, but you do have that right.
And so the bottom line is we need to get the process in most cases for when you're buying residential property in the state of Washington is to get a Form 17 from the seller, have the buyer review it, and make a decision on whether they'll go forward with the sale based on that information. And as Mike said, they need to make sure that in conjunction with that they do a very thorough investigation of the property. I'm E.J. Bolds.
I'm Mike Winkler. Till next time.